And you can't fire the agent if the agent goes wrong. And so you would, if you were the principal in those circumstances, you would want a less flexible system of interpretation. And that's fundamentally what I've been arguing. I do want to say one more thing, that there's an obvious difference in the assumption between Judge Calabresi's analysis and mine, which is that Judge Calabresi is assuming that if you have to interpret an old statute and the linguistic community in which that legislation came about, the linguistic and economic and legal community in which that legislation came about has been lost, and you really can't recover its meaning, then the judge has to do something in the name of that statute. My view is if you really can't recover its meaning, instead of making something up in the name of that statute, you just put that statute down and say it doesn't bear on our problem. We go to whatever is next in line, some other law, or the principle in the United States that unless Congress has enacted a statute, private ordering prevails. We don't have a presumption that if Congress has ever enacted a statute, then public ordering must prevail. That doesn't seem to me the correct way to go about it.
If I may answer, I was very interested in Frank saying, do you want this or do you want that? And then his talk about private agents and public agents. I read our topic to be resolved, the United States Constitution requires federal courts to interpret statutes as honest agents of the enacting Congress. I'm reading that literally. Yes, as honest agents. Frank is telling me, yes, but not honest agents as we usually use the word honest agents. I wanted to read something else because I don't like that meaning or think that meaning doesn't really apply well to legislators. So the way we always use these words shouldn't apply here because that has undesirable consequences that I don't like. And that, of course, is what often happens with the literalistic interpretation that he does. What is more, his approach is totally ahistorical. That is not what courts did in the 18th century. It is true that they didn't in England look at legislative history for good and sufficient reason, but they always looked at the mischief that the statute was enacted for. I can give you 100 torts cases where they did that, statutory torts cases, where they begin by saying, what is the mischief that this law was allowed to do? And then proceed to read it in that context. The other thing is, there is here an underlying fear or confusion, as if we were talking most of the time about constitutional interpretation. Remember, we're not. We're talking about statutory interpretation. And that's important because if we as courts get it wrong, our mistake can be corrected. Now, of course, if our mistakes could be corrected easily, if there were no equivalent of political transaction costs, political transaction costs, then of course it wouldn't matter, really, what anybody court said because the legislature would act immediately. In a Coasian political world, everything would be fine. We don't have that word. There are enormous inertial effects with respect to the starting point in non-constitutional interpretation. The inertial effect in constitutional interpretation is much, much bigger. With respect to statutes, it is still big enough. We should remember that these political transaction costs are not there accidentally, and they're not there for lack of desirability. They were put in there by the framers who did not like legisferation, Wilson's word, meant to be ugly. They didn't like statutes to be enacted, and so put obstacles to changing. The only thing we do as courts, as honest agents, is to try to find the best starting point from which, if we do it badly enough, despite the inertial effects, legislatures will react. That's a very important job because the inertial effects are very great. But then the question is, do you think the best starting point is one which simply goes along with language which is misinterpreted to mean what it doesn't mean, as Frank did with respect to honest agent? Or do you think the best starting point is to try, knowing your limits, starting with language, in context, to figure out what was wanted, skeptical when conditions change, if it is possible when conditions change to say, then there is no law, that's very good, but there are times when conditions change when you can't do that. One of my favorite examples is Nebraska passes, I think it was Nebraska, passes a law saying cattle may run at large, you do not need to fence them in. But if they go through a fence and enclosure, then the cattle pays damages to the person whose enclosure has been gone into. This statute passed by the ranchers to have free ranching in Nebraska. You cannot, as a big landowner, fence in your land because there is no timber. Somebody invents barbed wire. The statute now has exactly the opposite effect. Ranchers are out. Magna agriculture is in. I don't know if courts should do something about that, but it's not enough to say in that context, oh, the statute doesn't apply, there is no statute. That doesn't get you anywhere. That might apply somewhere, but somehow a court is going to have to face that, as they did had to do in the 19th century, and there are dangers doing it either way, but simply saying, oh, I follow the language, that's fine, isn't going to get you very far.
Thank you both. So I'm going to ask a couple of questions, and my first one will be to both of the distinguished judges here, and half of it you'll see is directed at Judge Easterbrook and half directed at Judge Calabresi. So the topic is, as Judge Calabresi just reminded us, the United States Constitution requires federal courts to interpret statutes as honest agents of the enacting Congress, and we've heard arguments from both about what the Constitution requires. So I just have a couple of follow-ups on that. So undoubtedly, the founders began their lives as English men and women. The founding generation began their lives as English men and women, and they read English law books, and this is what Blackstone's commentaries had to say about interpretation. Blackstone, by the way, was widely regarded as the hornbook of choice for the founders. Okay, so here's what Blackstone said. The most universal and effectual way of discovering the true meaning of the law when the words are dubious is by considering the reason and spirit of it. And here's the important part. For when this reason ceases, the law itself ought likewise to cease with it. He goes on to say that since in laws all cases cannot be foreseen or expressed, it is necessary that when the general decrees of the law come to be applied in particular cases, there should be somewhere a power vested of defining those circumstances which, had they been foreseen, the legislator himself would have expressed. So if this informs the founders' understanding of the judicial power, why is Judge Calabresi not correct? That's my question for Judge Easterbrook, obviously. Now my question for Judge Calabresi. Judge Calabresi mentions that all of the states had either constitutional or statutory devices for receiving the common law, which is my understanding as well. And so one, as a big fan of the expressio unius canon, the negative implication idea, I can't help but notice that the U.S. Constitution does not, neither the U.S. Constitution nor any act of Congress purported to receive the common law at that time or any other time. And let me add one other piece of this. In 1815, Joseph Story wrote for the Supreme Court, The statute is expressed in clear and unambiguous terms. We cannot interpose a limitation or qualification upon the terms which the legislature itself has not imposed. Public policy or principle must be addressed with effect to another tribunal.